guys. Okay, so last session we were talking about the United States Constitution. So this session we're going to talk about the Texas Constitution. And we're going to start with very early on in our history when we were the Republic of Texas. So we used to be our own little country, but even then we established some core principles that you're going to see in practice today. We established term limits on what was then the president. Understand now, obviously, in our executive branch, the head is going to be the governor. But at the time, since we were our own country, we established term limits on the president. Now, remember, term limits are how often somebody can serve in that position. So are you able to serve 2 terms? Are you able to serve 3 terms? Is there any term limit at all? Early on, we established a term limit. So we didn't want to consolidate power behind just one individual. We also included separation of church and state, so we thought that was an important facet to incorporate into our Constitution. And we had some really important provisions from Spanish and Mexican law. So we've touched on this a little bit before, but remember that we're different from a lot of other states in that we were really heavily influenced by Mexican laws as opposed to just English laws. So these things that we're about to talk about here, these next 2, homestead and community property, this is going to look a lot different in Texas than it does in a lot of other states. So let's start just by talking about homesteads. What is a homestead? A homestead is your house. So it's where you live, it's where you reside, it's the place that you own. So owner-occupied properties. And in Texas, they're protected from forced sale under most circumstances. What that means is, so let's say that you have $1 million house. It has $1 million worth of equity. You could sell it today and get $1 million. Let's say that you owe Visa $100,000 and you default. You don't pay them. In Texas, Visa can't come in and force the sale of your homestead. They can try to get that money through other means, but they can't force you to sell your home and get their debt from that forced sale of the homestead. There are situations in which a creditor can force the sale of a homestead in Texas, but they're pretty narrow. So most of the time we're talking about things like taxes, a mortgage, HOA fees, usually something connected with the house itself. When we're talking about independent debts like medical bills or credit card bills or unsecured personal loans, those things, even if the creditors owed a bunch of money and even if you have a whole bunch of equity in your homestead, they're not going to be able to force the sale to get paid. Now, a lot of people are going to say that doesn't seem very fair. Well, there's a flip side to that, right? The scenario we just used was one in which somebody had $1 million homestead. But most of us don't have $1 million house, which is we might want one. Most of us are living probably somewhere in the $300,000, $400,000 house price point. And most of us, not all of that is equity. There's usually a mortgage. So for most regular people, if we force the sale of their home, that's going to put them into a really bad situation financially. So now they no longer have somewhere to live. We've wrecked their credit. Potentially, we're going to have a homelessness situation. That's really what Texas was concerned about when it enacted its homestead protections. So that's homesteads. Owner-occupied property that is exempt from forced sale from most creditors. Okay, now let's talk about community property. So community property is property that's acquired during the course of a marriage. The general rule is that if property is acquired during the course of a marriage, it's going to be considered community property. If you acquired it through inheritance or some other means, or you acquired it prior to marriage, it's going to be considered separate property. For community property, the presumption is that it's going to be 50% yours and 50% your spouse's. It doesn't matter how much or how little one of the spouses has worked in relation to the other. So if you've gone and busted your butt and worked 80 hours a week and your spouse sat on the couch and ate bonbons and it's 5 years later, your spouse is probably going to get 50% of whatever was earned during the course of the marriage, because we don't usually look to see how much either party was working. Now, again, you're probably going to say that doesn't seem very fair. The thought process here was that most people don't have a spouse who's at home eating bonbons while the other one is out working 80 hours a week. Most of the time, we're talking about a situation where one person stayed home, took care of the house, took care of the kids, took care of whatever else, and the other person was out working. And so we have kind of a joint partnership going on. And so we don't want to say, okay, well, that person who stayed home and did the dishes and took care of the kids and did whatever else and ran to the grocery store, their contribution was meaningless because it wasn't monetary, because the other party derived some benefit from it. So that's the idea of community property, is this idea that generally speaking, anything that's acquired during the course of the marriage is going to be considered 50% yours and 50% your spouse's, regardless of how much or how little you've worked. Okay, exceptions to that would be separate property. So that would be anything that you brought into the marriage. That would include gifts. It would also include inheritance. Common law. Common law is going to be something that we see in all 50 states. It's law that's developed from judicial rulings and customs over time. So sometimes the legislature will enact a law and it'll look ambiguous. And so the two parties think it means different things. And we'll see somebody go to court over it. Well, the court's decision about what that law actually means becomes the common law. The common law is basically law that is given through judicial interpretations as opposed to statutory law that the legislature writes. Okay, so that's our early Texas Constitution. Now let's move on. We've got the Constitution of 1845. And I should just tell you before we get too far into this chapter that you're going to see several iterations of our Constitution. So apologies in advance. But we're going from the beginning, and then we're kind of pulling out what are some of the more important aspects that we should focus on. So the Constitution of 1845 restricted the power of the legislature. Now, why would we do this? Early on, you saw in Texas government a real effort to put more power in the hands of local government than state government. So if the state legislature is meeting less often and for less time, then just by necessity, there are going to be less state laws that are passed, and there's going to be more local control that's exerted. So as early as 1845, we really start to see this development. We also went in and limited state debt to $100,000. You're going to see limitations on state debt in Texas to this day. It's one of the things that we're actually well known for in a positive way. We have a very balanced, good economy here in the state of Texas. And we also established the permanent school fund as well as the long ballot. The permanent school fund, basically just a fund that is derived from revenue off of public land. So just like you can go out and you can own a piece of land, the state of Texas owns pieces of property, pieces of land. And maybe some of that land has mineral interests under it. Well, when the state government goes out and they lease that interest in the property, that mineral interest, the revenue that's derived from that is put into a separate fund. That fund is the permanent school fund. It funds primary and secondary public schools in the state of Texas. It used to be our primary source of funding. It's no longer our primary source of funding, but it's still a big source of funding in the state. We also went in and we established the long ballot. So the long ballot is exactly like what it sounds like. It is a ballot that is long. If any of you have gone and voted, which if you haven't and you're eligible to, I would highly encourage you to do so. But if any of you have gone and voted in Texas, you know that it's going to be on those digital machines. You're going to have to go through several pages. And that's because we don't have just a true cabinet system in Texas. We basically have a hybrid system, which means that the governor isn't going in and appointing every single office. Instead, the voters get to go in and select a large number of the people to fill those vacancies. So this long ballot that we see in Texas today, it really started back with the Constitution of 1845. Okay, so then we have the Constitution of 1861. Why did we get a new constitution? Well, if we look back at what was happening in history, Texas had joined the Confederacy and had seceded from the Union. So this constitution looks very similar to the 1845 Constitution, but it acknowledges Texas as a Confederate state. Okay, so then what happened? Well, we decided that whole seceding thing wasn't such a good idea, so we have the Constitution of 1866. This Constitution went in, it nullified secession. So it's a just kidding about that. We didn't really mean it. It abolished slavery, which, remember, was one of kind of the central sticking points in the Civil War, and it renounced Confederate war debt. So renouncing a debt, what does that mean? Basically means we don't have to repay it. So you can imagine that there are a large number of people who are very unhappy about this state of affairs. Anyone who loaned money to the Confederacy is not particularly endeared to them during this period of time. The Reconstruction Act of 1867 voided this Constitution. Basically, the federal government, just like the southern states, the Confederacy was pretty upset with the Union. Well, the Union was pretty upset with everyone who broke away in the Confederacy. And so the Union wanted to basically get pre-approval over all state constitutions to make sure that they were checking all of the boxes that they were supposed to do. So the Reconstruction Act of 1867 ended up voiding this Constitution, which gives us a new Constitution of 1869. The Constitution of 1869 looks markedly different than the other constitutions that we've seen so far or that we see going forward. Before, remember, we said we were all about limiting the power of the state. With the Constitution of 1869, we centralized state power in the governor's hands. So we gave the governor a lot of power. And what we did is we actually went in and we lengthened the governor's term, and then we gave more power to the legislature. So if we're thinking back to our early constitutions, we remember from the very, very beginning, we were concerned about limiting the power of the legislature. Well, now we're providing for annual legislative sessions. So that means that our legislature is going to get to meet every year, which means that more state laws are going to be passed. So less power to the local government, more power to the state. We also centralized the public school system. And during this period of time, there was a Republican governor in office. His name was E.J. Davis. He was exceptionally unpopular among people within the Confederacy who had broken away because he actually fought for the Union. This period of time was not a great one for Texas. There were large gifts of public funds that were made to interests such as railroads. Tax rates skyrocketed to pay for ambitious and wasteful public programs. Many Texans simply refused to pay the exorbitant taxes, and the state government actually accumulated a fair amount of debt, which, as we talked about previously, is definitely not something that Texas was or is currently known for. So we needed to go in and we needed to make some reforms, which results in the Constitutional Convention of 1875. So here we go in and we cut salaries for governing officials, and we stripped most of the governor's power away. So while the governor had all of this power previously under the Constitution of 1869, now we see some restrictions being put on his power. We're also going to go in and place limits on property taxes because, remember, that was a big sticking point in the last Constitution. And we're going to limit our legislative sessions again. So instead of having the legislature convene once every year, we're going to go back to the biennial legislative sessions. We're going to have our legislature meet once every 2 years. Now notice that I said biennially and not biannually. It's important to keep those two distinct. biennially means once every 2 years. Biannually means twice a year. So the new Texas Constitution says they're going to meet once every 2 years. And as a result, we went in and we strengthened what local government can do. So what does our Constitution look like today? Well, it's a very reactionary document. And when we say it's a reactionary document, we mean it's basically reacting and responding to what's going on in history during this period of time. So you can see our response changes based on the political atmosphere. We are the second longest among the states, has 88,500 words, and is 11 times longer than the U.S. Constitution. It also contains a Bill of Rights that's very similar to the U.S. Constitution. So a lot of people at this point might wonder, why do we have a Texas Bill of Rights if we also have a United States Bill of Rights in our U.S. Constitution? Well, there's more than one answer to that, and all of them are good. So while the Texas Constitution could never go in and decrease protections that the U.S. Constitution provides, because remember, that would be a problem with the Supremacy Clause, we can go in and we can heighten protections. We can also safeguard them, so we can make sure that we are strengthening protections for Texas citizens, and we can make sure that we are preserving protections, just in case anything were to ever happen, any amendment were to occur to the United States Constitution. So those are a couple of the reasons that we're going to see this overlap here. Another reason is that we can also see some additional protections provided. So I've gone through and I've pulled out some of them for you. We've got prohibits discrimination based on sex. There's actually nothing that explicitly prohibits discrimination on the basis of sex in the United States Constitution. It has been read into the U.S. Constitution, but there's nothing that explicitly states it. The Texas Constitution is different. It explicitly prohibits discrimination on the basis of sex. We also guarantee victims' rights in the Texas Constitution. So victims are constitutionally afforded the right to be apprised of any proceedings, any criminal proceedings that are to occur, and they have the right to be provided with precautions, basically basic safety measures to make sure that the victim is protected while attending court proceedings. We forbid the imprisonment for debt. So there used to be things called debtors' prisons where if you didn't pay somebody, you could basically be thrown into prison as a result. We decided that's not a very good idea because people obviously can't pay off their debts if they're in prison. We prohibited monopolies. So we said we're not going to allow one business enterprise to come in and control everything. So a monopoly would be like AT&T is the only cellular provider in the state of Texas. That would be a monopoly. They're not, right? So instead, we've got AT&T, we've got Verizon, we've got any number of other providers as well. And we also provided for the suspension of the writ of habeas corpus under any circumstances. So a writ of habeas corpus is just a court order to present a person and show the legal cause for confining the individual. It usually is going to result in a prisoner's release from unlawful detention. So what this is let's say that you're in North Korea, right? If you are alleged to have committed a crime in North Korea, are you going to be given any protections? Probably not. You're probably not going to receive any sort of due process, right? And that includes you're probably just going to be thrown into a cell. You might not know the charges that you're facing. You might not stand trial for a long period of time. Your family members might not know where you are or why you're being held, which means it's really hard to make sure that the prison is providing for your basic welfare and for you to actually mount any kind of defense. A writ of habeas corpus is designed to basically stop that situation from occurring. So if we don't know where somebody is or why they're being held, it allows for the court to go in and order that individual to be produced and to state the charges against that individual. So what Texas has done is it's gone in and prohibited a suspension of the writ of habeas corpus. under any circumstances. And this is definitely different than what we see in the United States Constitution. Okay, so don't memorize these. This is just designed to give you an overview to see that there are a lot of areas here that we're going to see overlap between the Texas Constitution Bill of Rights and the U.S. Constitution Bill of Rights. Religious liberty, freedom of expression, right to keep and bear arms. That's obviously going to be a big one in Texas. Right to grand jury indictment for felonies. There's going to be a lot. So this chapter of your textbook is going to go in and it's going to talk a little bit about each of the three branches of government. And the reason that they're doing that in this chapter is, number one, it gives you an overview of what we're going to cover more in depth later on. But also, in addition to giving you that overview, this chapter, when we're talking about the Texas Constitution really structures the way that our government is set up here. So just like in the United States, Texas has three branches of government. So on the federal system, we've got the legislative, executive, and judicial. On the state level, same thing. Legislative, executive, and judicial. So just as a review, in case you have maybe forgotten, the legislative branch is going to be the branch that is in charge of drafting the laws. The judicial branch is the branch that is in charge of interpreting the laws, and the executive branch is the branch that's in charge of enforcing the laws. So the way that we've structured our state system of government is just like the federal government system, and that there's a series of checks and balances. What that means is we wanted to make sure that no one branch of government became too powerful. We didn't want there to be one branch that could potentially abuse its powers. And so we have each branch of government assigned power to limit abuses by the others. This goes into this concept of separation of powers. So the principle behind that concept is one of a government in which power is distributed among at least three different branches. We don't want one branch to become too powerful, and we want to make sure that we've got power distributed and checked between the branches. So we're going to talk more about this in a bit here, but you can see some of the examples that we have of checks and balances. We've got veto power, impeachment and conviction, and confirmation of appointments. So veto power is where the governor steps in and says, I don't like this thing that the legislature wants to pass into law, and so I'm going to veto it. I'm going to keep it from happening. Impeachment and conviction, this is basically where somebody has messed up and we want to remove them from office. And confirmation of appointments is where we go in and we have the Senate confirm any gubernatorial appointments that are made. Okay, so let's start by talking about the legislative branch, and we're just going to go through this briefly because, again, this is designed to just sort of be an overview for you. We're going to cover this a lot more in depth in the subsequent chapters. So for the legislative branch, we have a bicameral legislature. That means that we've got two chambers. Almost every state in the union has two chambers, a House and a Senate. Nebraska is going to be the exception to this. They have one chamber. They have a unicameral legislature. But here we have a bicameral legislature. So we've got the Senate and we've got the House. The House is going to be the larger chamber. Senate is going to be the smaller chamber. So there's 150 members in the House of Representatives, and there's 31 members within the Senate. Here's something that's kind of notable about our legislators. Remember how we said after the Constitution of 1869, we went in and slashed governing salaries? Well, they have an annual salary of $7,200, which when we get to Chapter 7, we're going to talk about some of the issues that presents. But suffice it to say, most people don't really want to earn $7,200 a year. And so this results in them either coming from a lot of wealth or needing to have second jobs in order to be able to serve. Now, the flip side to this is that it's $7,200 a year, but they're not there for the whole year. They're only there for 140 days, which we're going to get to in just a second. Okay. So remember, we've got those biennial regular sessions once every 2 years. They're limited to 140 days, and the governor has the ability to call a special session. So think back on that Wendy Davis clip that we watched. The governor went in, called a special session. That special session is basically calling the legislature back into order, but it can't last for any more than 30 days. And it's more restricted in Texas than we see in any other state. The governor really has a lot of control over that special session. So the governor gets to go in and basically call the agenda for what's going to be considered in terms of new pieces of legislation. Okay, so the executive branch. We just talked about the legislative branch, so we talked about the people who make those statutory laws. Now we're moving over to the executive branch, who's in charge of enforcement. The governor is going to be the head of the executive branch within Texas. So just like the president would be the head of the executive branch on a national level, the governor is the head of the executive branch here. We have what's known as a plural executive. So technically, we have some cabinet positions, which means that the governor does get to go in and appoint some allies into key positions. But if you think back on that long ballot that we talked about earlier in this chapter, we said the reason it's so long is that Texas voters have a lot more selection over who's going to serve in public office. And part of that is because of the plural executive. So this is an executive branch in which power is divided among several independently elected officials. And it thereby weakens the governor's power to act as the chief executive. So instead of the governor getting to fill all of those places with individuals that are on his same side, political allies, the people are going in and picking. So in theory, although rarely in practice, we could go in and elect Democrats to serve along a Republican governor or vice versa. So it weakens the power that the governor has to some extent. The governor is going to have limited removal power. So within the executive branch, there's a whole bunch of different agencies, boards, and commissions. The governor has the ability to go in and make appointments and also make removal, but those powers are limited. So let's switch real quick over to the Blackboard. And I think there's going to be like a little bit of a time delay that ends up on y'all's side when I start writing on the Blackboard. So sorry about that in advance. Okay. So let's say, do this. Okay. We're going to say that this is a Texas agency that I'm drawing here. And let's pretend there are 6 people serving on this particular board. Okay. Each board or agency is going to have somebody who heads up that organization. The governor does not get to select the head of that organization, but the governor does get to select those other members. They are going to serve in staggered terms so that once every 2 years, a third of those positions are going to be open and the governor gets to fill them. Looks like some kind of bizarre robot. Sorry. This is even worse than my usual drawings in class, but you get the idea. These people then get to select, all the people down here get to select who's going to head up this agency or board. So indirectly, the governor gets say over who is the head of all of those organizations within the executive branch. So the governor doesn't have direct control, but does have indirect appointive power over the head. Now, for removal, let's say that the governor has only served for a year and a half or 2 years. All right. Well, the governor's got to put these 2 people on here, right? But the other 2/3 of the agency, the governor has not been able to fill those vacancies yet because they're not yet vacancies. They haven't come up for a reappointment. So let's say over here, this individual did something that the governor didn't like, but a previous governor appointed that individual. Well, the governor can't remove that person that the previous governor appointed. But the governor can remove the individual that he or she appointed. So that's what we mean by indirect appointive powers and limited removal powers. And we're going to talk more about that later on. So I don't want to get y'all like too deep into the weeds. It's just that this chapter in your textbook does kind of start down the path of what happens within the different branches. So we're going to hop back over. We're going to go back to the PowerPoint slides, and we are picking up on slide 17. Okay. So the judicial branch. When your textbook says that the judicial branch, the branch with all the courts, has a fragmented court system, what they mean is there are going to be courts that originally hear the cases, and then there are going to be courts that hear the appeals of the cases. When it comes to the appeals, the 2 highest courts, so the courts that review those lower courts' decisions, they split. They bifurcate in 2. And so on the one side, you've got the Texas Supreme Court that's going to handle things like family law disputes or probate disputes or real estate disputes or corporate disputes. All of those things are known as civil matters. On the other side, you've got the Texas Court of Criminal Appeals. That's going to be the final appellate court for criminal matters. So things like robbery, burglary, theft, murder, all of that. So when we talk about that fragmented court system, we're really talking about a bifurcation, so a splitting in 2 when it comes to the highest level appellate court. These courts that are listed here in your slide, the Court of Appeals, District, County, and Justice of the Peace courts, those are going to be courts that actually get to hear and decide cases. And most of our courts, really all of the ones listed here, are going to allow for what's called partisan elections. That means that our judicial officers, our judges, are selected through an election process. So when you go to the polls, one of the things that you get to vote on is who you want to serve as your local family law judge or your local probate court judge. Partisan means that those individuals are running as either Republicans or Democrats or independents, which also kind of opens up a whole host of issues that we're going to talk more about when we get to that chapter. Okay, voting rights in Texas. The Texas Constitution in Article 6 specifically provides voting rights, and more specifically goes in and says who is not entitled to vote in Texas. So the first thing that you have to know is that in order to be eligible to vote in the state of Texas, you have to be a citizen of the United States and you have to be a resident of Texas. So we need those two things first. From there, if you have those two things, we assume that you can vote in the state of Texas unless Article 6 specifically denies you that right. So Article 6 is going to deny voting rights to individuals who are under the age of 18. That one's easy. Minors can't vote. Certain convicted felons. This part is a little bit more difficult. It doesn't mean that anyone with a felony conviction can't vote. It means that anyone who is still serving their sentence in any way can't vote. So if you're on some kind of a supervised release, like probation or parole, or if you're still currently incarcerated as the result of a felony, then you are not able to exercise your right to vote. You are prohibited from voting in Texas. This last one is or legally declared mentally incompetent. This means that a court has gone in and said, you don't get to make your own decisions anymore. It's a very extreme remedy called basically guardianship, where the court has gone in and they say, you no longer have the ability, the mental ability, to make determinations for yourself. Usually it's somebody who is suffering from an advanced form of like Alzheimer's or dementia or other cognitive issues that prohibit them from actually being able to make that type of decision. So a lot of times you'll see this grandpa or grandpa, is going in and grandma's, supporting 15 Nigerian princes in Africa. That's probably not going to work to let grandma be in charge of her own affairs anymore. So that's an example of when somebody would be declared mentally incompetent. So it's mentally incompetent as declared by a court. So assuming that you are a United States citizen and a resident of Texas, and you are not under the age of 18 or a convicted felon or legally declared mentally incompetent, then we go with the assumption that you are allowed to vote. Now the next question becomes vote in what type of elections? Technically, we could have something called direct democracy in Texas. That's where we rely a lot less on our representatives, and we allow individual Texas citizens to come in and make decisions. But our Texas Constitution does not allow for forms of direct democracy. Forms of direct democracy would include things like statewide initiatives, statewide referendums, and statewide popular recall. Now notice we've got statewide here. When we get to local governments, this is going to look different. But on the statewide level, we don't have any forms of direct democracy. So let's look a little bit more specifically at what that means. An initiative is a process that empowers citizens to place a proposal on the ballot for voter approval. If the measure passes, it becomes law. So again, it's going to be permitted in some Texas cities. We're not talking about municipalities right now, but we're talking about at the statewide level. Referendum. This is going to be an election that permits voters to determine if an ordinance or statute will go into effect. So let's say that the legislature passed a law and you didn't like it. There's usually a 90-day period between the bill's passage and when it actually becomes law. If our state allowed for referendums, then you could go to the polls and you could say, I know that the legislature voted for that, but we don't want to see it passed. Our state doesn't allow for that. Initiatives, real-world example, would be we wouldn't be reliant on our legislators to basically introduce pieces of legislation. So if you really wanted marijuana to be legalized and we allowed for statewide initiatives, you, the voters, could make that happen without having to rely on your representative. Again, on a statewide level, we don't allow any forms of direct democracy. Popular recalls are also not allowed. That's a special election to remove an official before the end of his or her term, which would be initiated by citizen petition. So, good example of this that I usually use in class is the Brock Turner case in California. That was the kid who, the swimmer who was convicted of raping that girl, but received a very, very light sentence. the California voters were very understandably outraged by that decision. And so they went in and they called for a popular recall. They basically said, we don't want this individual to serve on the bench anymore. So it's a means of recalling somebody before their term, not because they violated any law or because they did something that was, sneaky or underhanded or violated their oath in some way. So it's not the same thing as like an impeachment and conviction. It's basically just we don't like the decisions that this person is making. We don't like how they're conducting themselves. And so we're going to take them out of office early. This next slide here is just designed to give you some context. All of the states in red allow for some form of direct democracy. So it doesn't necessarily mean that they have everything, doesn't mean that they have initiatives, referendums, and popular recalls, but there is at least one form of direct democracy that's allowed on a statewide level. The more tannish states you can see are the states that do not allow direct democracy. So while we are not alone in not allowing it, we are in the minority. Okay, so our Texas Constitution next provides for public education, and it establishes the right to a free public education for primary and secondary school students in the state of Texas. Now, what exactly that means has become a point of controversy. There's this case, Edgewood Independent School District versus Kirby, where there was this school district from this really low-income neighborhood. And the thing that you have to understand about school districts and funding in order to understand this conversation is that we talked earlier on about the permanent school fund and how it's still in existence, but it's no longer the primary source of funding for schools. Now schools mostly rely on property taxes. So if you live in a really affluent area, like if you come from the Colleyville Grapevine area, then your schools were probably receiving a fair amount of funding in the form of property taxes. Whereas if you live over in like East Fort Worth, for example, they have a lot of neighborhoods that are less affluent. And so there's less money from property taxes to go into their school system. Well, in this Edgewood Independent School District versus Kirby case, what we saw is this really impoverished district that really didn't have access to pay their teachers fair compensation, so they were losing teachers left and right. They had really old textbooks. They couldn't buy basic supplies. And then you had other school districts, like in the Austin area or right outside of it, that had just paid for new stadium billboards for their football team. And so the really poor districts got upset and basically sued and said that the education they received as a result of this lack of funding was so poor that it violated the Texas Constitution. Now, understand, though, that the Texas Constitution was, just one second. Understand that the Texas Constitution was providing for a free Texas public sorry, I'm trying to make the attendee controls because I think people are trying to enter into the session. It's not going to make a whole lot of sense if they come halfway through. I can't do both at the same time, so hold please. All right. Let me go backwards. Hold on. Okay. All right. All right, I'm back on track now. So Texas Public Constitution provides for free public education. And sorry to whoever I just kicked out of here, but it really isn't going to make sense if you hop in like halfway into the lecture. So these are all going to be available, though, obviously, as you know, through recording. So here we've got this ongoing debate on funding that is occurring. And the reason for that is that these really impoverished school districts believe that they weren't receiving the free public education guaranteed to them in the Texas Constitution. They thought that the lack of funding was so severe that they actually weren't able to provide their students with a free public education. And very surprisingly, the Texas Supreme Court agreed with them and said, yeah, we do think that that violates the Texas Constitution. What that resulted in was something called the Robin Hood Plan, which, as most of you are familiar with, Robin Hood was somebody who went in, stole from the rich, and gave to the poor. Well, what happened was we started diverting funding away from those more affluent districts and funneling that funding towards the poorer districts. Now, this has resulted in a lot of controversy in Texas, and we basically now have like a modified Robin Hood plan. So not every single school receives the same amount of funding, but there is a guaranteed amount of funding from the state that's provided to each school. So the Edgewood Independent School District versus Kirby case, that Robin Hood plan and the modifications that have come from it are all a result of what was happening with the Texas Constitution. Okay, local government. Our Texas Constitution provides for the setup of local government, and understand that in the United States Constitution, it's silent when it comes to local government. So it's up to the states to provide those. We have provided for local governments. We've made them subordinate to the state. So just like the state is subordinate to the federal government, the local governments are going to be subordinate to the state. We decentralized government power. So we've given a lot more power over to the city governments, which we have a whole chapter on. So just briefly, we've divided those governments into two different types. We've got cities that are known as general law cities and cities that are known as home rule cities. General law cities are going to have general law charters, and home rule cities are going to have home rule charters. General law cities are basically just cities that are a lot more narrowly constrained in terms of how they can structure their government and what they can do. Home rule cities are cities that are going to have charters that provide for much more expansive power and much more decision making in terms of how they want to structure their governments and what they want to do there. We also allow for something called special districts. This is basically a different form of local government that allows for additional resources to be pooled for specific purposes. Things like water or hospital districts, things like that are considered special districts. That's just kind of a very brief overview for you. We're going to have a whole chapter devoted to that later on. Okay, so what happens if we want to amend the Texas Constitution? Well, it's a two-step process. So the first step starts with the Texas legislature. So that's where the proposal step is going to start. It needs to be supported by 2/3 of the total membership of each house of the Texas legislature, meaning both chambers need to be in support. So at least 21 senators and 100 representatives need to agree to send it to the voters. So after we have the Texas legislature approve it, the second part of that process is it goes to the Texas voters for approval. So recent constitutional amendments. We have had 1,145 proposed amendments since 1997, which is obviously quite a lot of amendments. The voter turnout is relatively low, and in the past 20 years, 90% of amendments have been approved. Those that are rejected are oftentimes seen as backdoor attempts to increase taxes. So overwhelmingly, if a proposal for a constitutional amendment passes by 2/3 of both chambers and makes it to the voters, it's probably going to pass and become a constitutional amendment. The only times we really see those fail is when we're looking at things that are designed to increase taxes. That tends to not be very popular. Criticisms of the Texas Constitution today are that it's a very long and very detailed document. A lot of people feel like it's poorly organized and confusing. Part of that has to do with the large amount of detail and length in the document. So our Constitution has statute-like detail, which means that over time, we have some provisions in there that just are no longer applicable as society evolves. That's part of why it's very detailed and part of why it's very restrictive, because we rely a lot more on our Constitution, in part because we have those really restricted legislative sessions. Also, we've seen that voters show little interest in amendment elections, even though on the whole, amendments tend to pass overwhelmingly. Part of that has to do with the fact that we have extremely low voter turnout when it comes to these amendment elections. Some people have talked about potentially revising the Texas Constitution, but as of right now, it doesn't look like that's going to happen anytime soon. It looks like we're going to keep with the current Constitution with all of its criticisms, but also with all of the good things that we talked about with it as well. So this just kind of gives you an overview of Chapter 3. I hope it was helpful. If you have questions, feel free to email me. You can also ask to set up a Blackboard Collaborate session where we can talk to each other in real time.